The Supreme Court's conservative majority, which many Republicans fought to make happen with the explicit goal of overturning Roe v. Wade, well, it appears ready to do just that. At least that's the indication we got from the right-leaning justices in oral arguments yesterday over a Mississippi abortion law seemingly designed to target the nearly 50-year-old decision.
If I were to ask you what constitutional right protects the right to abortion, is it privacy? Is it autonomy? What would it be?
Why should this court be the arbiter rather than Congress, the state legislatures, state Supreme Courts, the people?
Can it be said that the right to abortion is deeply rooted in the history and traditions of the American people?
But if you ask some of the court's more liberal justices, the issue of history and precedent are exactly why Roe needs to be upheld.
There's been 50 years of water under the bridge, 50 years of decisions saying that this is part of our law, that this is part of the fabric of women's existence in this country.
You want us to reject that line of viability and adopt something different. But 15 justices have said yes, of varying political backgrounds.
To overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question.
So beyond the serious implications to abortion access if Roe v. Wade was overturned, what would such a ruling mean for the High Court's many other past decisions on the rights and protections we've come to count on? Well, I'm joined now by the executive director of the ACLU of Massachusetts, Carol Rose, and Amy Littlefield, the abortion access correspondent for The Nation. Welcome to both of you. Carol, I want to just jump in with you quickly. Can you just explain what this Mississippi law is? We've been paying a lot of attention to Texas in the news, as we should. But this Mississippi law seems to be the magic bullet here that could bring down Roe v. Wade.
That's right, Sue. I mean, this case marks the first time, literally in 50 years, that the court has agreed to hear a case on the constitutionality of pre-viability abortion bans. In this case, it's a ban at 15 weeks of pregnancy passed in Mississippi. The ban basically violates the Supreme Court precedent of Roe versus Wade, but also more recent Supreme Court precedents from like 1920 with June Medical Services versus Russo, that a state cannot ban abortion pre-viability, which is generally around 24 weeks.
Amy, you've certainly written extensively about this and abortion in general and abortion access, and most recently in the New York Times. What would happen if in June the court decides that they're going to side with the state of Mississippi? What immediately happens in the United States? This is a state decision, but it would have implications across the nation, right?
Absolutely. Absolutely. And of course, it depends on the details of exactly what the court says and how it says it. But as you pointed out, it seems pretty clear that they're willing to undermine 50 years of precedent and potentially reverse Roe v. Wade altogether. If that happened, we know that there are a dozen states that have so-called trigger laws in place that would immediately ban abortion. In those states, they're already teed up, ready to go in the event that Roe falls. And we know, according to the Guttmacher Institute, there are 26 states, so about half the country, where either the states are certain or very likely to ban abortion in the event that Roe falls. And these are states that either have laws on the books already from before Roe or have passed laws, just waiting for Roe to fall so they can go ahead and put those into place. And I'll say, we've gotten a preview of exactly how chaotic and urgent that looks with Texas, where, since September 1st, with a brief reprieve, there has been a law in place in Texas that bans abortion as early as 6 weeks of pregnancy, which is 2 weeks after a missed period. And what has happened is we've seen patients from Texas traveling as far afield as Massachusetts and California and Washington State, filling up clinic appointments so that you have to wait weeks for an appointment now in neighboring states because of how many Texas patients are flocking to anywhere they can get an appointment across the country. And so think about that, multiplied by, Texas is a big state, but we're talking about one state versus potentially 26, where we could have patients sort of facing that same mass migration.
I want to play 3 clips in a row to get your reaction. I know it's dangerous to try to read the tea leaves while the court is in session and hearing arguments. But first, I want to play the clip, the argument and questions that Justice Sonia Sotomayor had about the future of the court. Let's take a listen.
Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
Justice Amy Coney Barrett, who is sort of leaning into the idea that this is a pro-woman sort of argument that the state of Mississippi is making.
Both Roe and Casey emphasized the burdens of parenting. And insofar as you and many of your amici focus on the ways in which the forced parenting, forced motherhood would hinder women's access to the workplace and to equal opportunities, it's also focused on the consequences of parenting and the obligations of motherhood that flow from pregnancy. Why don't the safe haven laws take care of that problem?
And then Justice John Roberts, who seems to be having it both ways, this is the question that he asked.
If you think that the issue is one of choice, that women should have a choice to terminate their pregnancy, that supposes that there is a point at which they've had the fair choice. So viability, it seems to me, doesn't have anything to do with choice. But if it really is an issue about choice, why is 15 weeks not enough time?
So, Carol, Chief Justice John Roberts there seemed to be trying to make the middle argument, if there was one, that he seems to be saying we don't need to overturn Roe completely. We can just sort of, and I think Kavanaugh went on and said as well, just kick it to the states and let the people vote, if you will. Suddenly they're all about voting on what should happen. Is my reading directionally correct on that?
Yeah, no, I think it is. And what we see from those 3 clips, Sue, is that you have on one hand, Justice Sotomayor and others trying to make the argument that if the court is just really going to sway with the wind and overturn 50-year-old precedents without going through the stare decisis or sort of going through the analysis of why the case should be overturned really clearly and sort of making that case, then the court is just really political hacks, right? So the very institution of the court, the integrity of the court as an institution is on the line. And I think what you have is Chief Justice Roberts trying to counter that by saying, well, let's not then do that. Let's not completely just overturn Roe. Let's just say that it doesn't really matter what the weeks are, whether it's viability or not. And we'll just say that let the states decide. And so he's trying to see if I think he can have a narrower ruling than what I think the more far right justices are trying to do. But the bottom line is in the states where this is happening, the vote, it isn't about the individual right of the person who needs the abortion and needs that kind of healthcare to decide. We're talking about state legislatures. And no matter how a person feels about abortion, the question is, should it be up to the individual person making these most personal decisions about their future and their families and their bodies? Or should it be up to a bunch of legislators, whether at the state level or the federal level, to make those decisions for us? And I think that the vast majority of the American people believe that this should be an individual liberty, an individual right, and not one that's just a state vote by a state legislature, as if they know what's best for ourselves and our families.
Amy, this is a state case, which is not surprising. There have been other challenges around abortion access and abortion rights that have come from the states, and this one seems carefully crafted to have made its way to being heard by the Supreme Court. You write recently that we should not be surprised by this, that this has been something decades in the making. And also, you express some concern that some of the national organizations have been focused too much on the federal access to abortion rather than the states, and seem to be caught a little bit flat-footed around this immediate crisis that we're having right now.
Right. I think over the last, half century since Roe, the mainstream national groups in the pro-choice movement really got used to playing a sort of defensive strategy, which in some ways is not surprising because they had to deal with a constant fire hose of anti-abortion legislation coming out of state legislatures. And they were often responding to, crisis after crisis that seemed to be threatening the holding of Roe. But in my recent, article for the New York Times, what I did is I talked to more than 50 people involved in some way in the movement, legal experts and analysts and activists. And I asked them, look, no one's really going to dispute that this is a pretty low point for the abortion rights movement, right? We're about to lose Roe v. Wade. We're about to lose, the national right to legal abortion as we know it. And so what happened? How did we get here? And I think a real trend that emerged is the fact that while conservatives, for a whole range of, ideological and logistical reasons, have focused on really capturing state legislatures, right? And they made a huge stride towards that in 2010 when the sort of Tea Party-backed wave took over a lot of state legislatures across the country. And that's where we saw a lot of these anti-abortion laws really take off. Conservatives really focused on the states, and they focused on an incremental strategy in the states of restricting abortion access. And Democrats and the progressive movement, I think more broadly, even outside of just pro-choice organizations, really focused more on federal policy, federal elections, and preserving Roe rather than moving beyond it. And what I point out in the piece is that there were people, primarily women of color and, Black and Latinx people within the movement, who early on saw that this was not going to be a winning strategy because relying on institutions like the Supreme Court to just uphold, the status quo, it turns out was a risky strategy. And so what I highlight is the reproductive justice movement started in the framework was started in 1994 by Black women to say, we need to think beyond just the single issue of abortion. We need to think about the broad range of issues affecting Black women's lives, from, attempts at forced sterilization by the state to, the right to parent the children that we want to have, that they want to have in safe communities. And that framework is finally, I think, sort of moving more into the mainstream, thanks in part to the Black Lives Matter movement and a sort of national reckoning around issues of racial injustice. But I think we might be in a different place if that had happened earlier.
Right. Carol, just as we wrap up here, I just want to give you the opportunity to point out that if this is overturned, there are many who are concerned that there are other rulings by prior Supreme Courts that could also be vulnerable to the same sort of attack. Which ones would those be?
Oh, I just think there's a whole range of whether we're talking about equal marriage or whether we're talking about some of the sentencing disparities, things like that. There's just a whole range of things that could be under attack if the court just goes with an ideological right-wing pull, and it'll just lose its integrity. And to the point about, the need to have a more holistic approach, I think that shift is happening. I mean, on one hand, we have been fighting. We've fought more than 100 of these kinds of introductions of pieces of legislation just in the last couple of years alone. And that matters. But you're right. We're on the front lines, on the barricades. And while a lot of the civil rights groups look really powerful, we have limited resources. We need more. But at the same time, here in Massachusetts, we have been moving in that direction. For example, we passed the Roe Act in the last legislative session that codifies the right to abortion access here in Massachusetts, regardless of what happens with Roe versus Wade in the Supreme Court. And we're working on expanding our legislative agenda to include a wraparound services, thinking about the increased fetal and maternal mortality for people of color, for women of color, thinking and passing laws to make sure that they're protected across the board, not just in abortion care, but from cradle to school and beyond that, so that people have that kind of equality. So I think those shifts are happening, but I think it's incumbent upon us not to make false choices. I think it's really important that we have both strategies, and that's where the ACLU, using both fighting in the courts, in the legislatures, and on the street and online, is really where we have to go. And I think that's the kind of wraparound strategy that we need if we're going to protect the right to choose and the right to have abortion care, and frankly, more broader equality for women and all people in this country going forward.
Well, Carol Rose, Amy Littlefield, I appreciate both of you and your expertise. Thanks so much for joining me.
Great to be here.
Thank you.